Good afternoon. My name is Stephanie Smith and I am a Senior Associate at Michael Lynch Family Lawyers. Thank you for joining me today. I will cover family law for farming, rural and regional clients. To get started off today, I will touch on the history of farming, rural and regional matters in the Federal Circuit and Family Court, formerly known as the Federal Circuit Court and the Family Court, and how its consideration in the courts has changed over the years. I'll also touch on the four-step process, which is an overview of the process for assessing property settlement matters under the Family Law Act. And then we'll take an in-depth look at the issues to be considered by farming, rural and regional family law property settlement matters, which include what is the value of the farm, ownership, such as what is the farm and who owns it. Are there any actual or potential third-party interests, such as siblings, parents or adult children that need to be considered when assessing what the property settlement looks like? Who holds or owns water rights and who can expect to retain the farm in a property settlement. We'll also look at the contributions by the non-farming spouse to the farming endeavours, which include financial, non-financial and homemaker and parent contributions and how they are relevant to an assessment of adjustment of property, including the earning capacity of each spouse. And we'll finish off by touching on a few relevant cases in the area to provide a bit of a guideline on how the court assesses these matters in a practical sense. All right. History. Family law property cases prior to 1985 involving farms determined that land used for farming purposes and to produce an income were in fact in a different category from land that simply provided a place for the family home. Judges in these cases specifically looked at a section of the Family Law Act requiring them to consider the earning capacity of either spouse. The main consideration of these early cases was that it was necessary to protect the farmer's ability to earn income from the farm and to preserve the farm from sale. In 1985, however, a decision by the Appeal Court of the Family Court provided an important new direction for farming matters. The decision of Lee Steer and Lee Steer clarified that there is no farming case exception to the ordinary principles applicable to deciding family law property settlements. The case rejected any notion of preservation of the farm as a viable entity at the expense of the wife or the non-farming spouse. This case is still used today as a guideline to determine a property division. Following the Lee Steer decision, farms do not have any special status in family law. The same principles apply when one spouse inherited the farm or it was acquired during the relationship as in any other family law property settlement, which deals with assets, real assets, including inheritances. Farm cases, particularly after the 1995 decision on the marriage of Guthrie, indicated that the court considers a range of factors. The court considers not just, for example, the initial contribution by the husband of bringing the farm into the marriage, but also the contributions of both parties to farm work and domestic work, which includes the homemaker and parenting duties. The court also considers the future earning capacity of the wife after separation and the earning capacity of the husband, which in many cases may be his need to retain the farm, as well as ensuring a just and equitable outcome in each unique matter. It is important to note that the court considers the contributions of both the farmer and the non-farmer spouse. The court views contributions as the spouse, such as homemaking, parenting, and even working on the farm, just as important as the financial contributions of the farmer. The four-step process. The Australian Family Law four-step process refers to the approach by the Federal Circuit and Family Court to determine the division of property and assets in a family law matter after the breakdown of a marriage or a de facto relationship. The steps are designed to achieve a just and equitable division of property between the parties. Step 1. We identify and value the assets and the liabilities. This step involves compiling a comprehensive list of all the assets, liabilities, and financial resources of both parties. This can include properties, bank accounts, investments, businesses, debts, superannuation, and any other assets or liabilities in which the parties have an interest, whether held solely, jointly, or severally with any other person. It is essential to accurately value these items to have a clear understanding of the overall pool of the assets. The next step, number 2, is to assess the contributions of both the parties. In this step, the court considers the financial, the non-financial, and the homemaker and parenting contributions made by each party to the relationship. These can be both direct contributions and indirect, and include financial contributions like income earned throughout the course of the relationship, savings accrued during the relationship, as well as gifts and inheritances from third parties. It also includes non-financial contributions, which covers efforts in renovating properties, homemaking contributions, and those to rearing children. Contributions made before, during, and after the relationship breakdown are assessed as relevant. Step 3 is to consider the future need of each party. So this assesses the needs of the respective parties going forward after the property settlement. The step involves examining the future needs and takes into account various factors which include the age of each party, their relative health, and the earning capacity of each person going forward now that the marriage is broken down and they don't have the financial support of each other. We also look at care responsibilities for children, financial resources available to each party, and any other relevant factors that may impact their future financial situation. Step 4 is to ask the question, is the proposed settlement based on the first 3 steps just and equitable in all of the circumstances? It is important to note that in the application of the 4-step process, it can vary depending on the circumstances of each case, and there may be other factors to be considered as well. If parties can reach an agreement on their own, they can apply for consent orders to formalise the property settlement without the necessity of litigating the matter before the court. However, if they cannot reach an agreement together or through solicitor-assisted negotiations or mediations outside of the court process, they may need to file an application in the court seeking judicial consideration. In either case, it is advisable to seek legal advice from a family lawyer to navigate the complexities of the family law system. Farming couples who are separating should consider a number of issues, a few of which we'll touch on today. Number 1, what is the value of the farm, plant and machinery, and the stock? Valuing a farming enterprise in Australian family law can be a complex process and far more involved than valuing a residential property, as it requires considering various factors and financial aspects that are unique to the agricultural industry and can be unique to the nature of the farming enterprise that the couple have. The valuer should have a good understanding of the agricultural industry, including the specific type of farming involved, such as cropping, livestock, and dairy. So it's important to ensure an experienced valuer who deals with agricultural properties and farming enterprising is engaged. The valuer will require detailed financial information about the farming enterprise, which includes historical and current financial statements, tax returns, profit and loss statements, balance sheets, records of assets and liabilities, and any other relevant financial data. The valuer will also consider the physical assets of the farming enterprise, such as the land, building, machinery, equipment, and livestock. They will assess the condition and value of the assets based on industry standards and market values. Apart from physical assets, the valuer will also take into account intangible assets, which includes water rights, intellectual property, goodwill of the enterprise, licenses, which can all significantly impact its value. The current market conditions, including commodity prices, demand for agricultural products, and regional factors, can also influence the value. The valuer will analyse these factors to determine their impact on the enterprise's overall worth. The productivity and potential of the farming operation are crucial in valuing the enterprise. The valuer will consider factors such as historical and projected crop yields, livestock productivity, and any improvements made to the farming processes. The valuer will also take into account outstanding debts and liabilities while calculating the net value of the assets. Valuing a farming enterprise may involve multiple valuation methods, such as the asset-based approach, income approach, and market approach. The valuer will apply appropriate methods depending on the circumstances and availability of data. Once the valuation process is complete, the valuer will provide a formal valuation report outlining the methods used, data considered, and the final value of the farming enterprise. In family law matters, the valuation report may be presented as evidence in court if the parties cannot reach an agreement on the property settlement. Number 2, ownership. What is the farm and who owns it? In Australia, there are several ownership structures for family farms, each with its own implications and legal considerations. The most common types of ownership structures we'll touch on today. The first one I'll look at is sole proprietorship. In a sole proprietorship, a single individual owns and operates the farm. This is the simplest ownership structure and provides the owner with full control and decision-making authority. However, the owner also assumes all the risks and liabilities associated with the farm. From a legal standpoint, there is no legal distinction between the individual and the farm business, making the owner personally liable for any debts or legal issues. Another type is a partnership. The partnership involves 2 or more individuals, known as the partners, who come together to own and operate the farm as co-owners. Partnerships are typically governed by a formal partnership agreement, which outlines the responsibilities, rights, and profit-sharing arrangements among the partners. Each partner is personally liable for the partnership's debts and obligations, and their personal assets may be at risk. Another is a family trust. A family trust is a legal entity established to hold and manage the fund's assets and business operations on behalf of the beneficiaries, who are usually family members. The trustee may or may not be a family member, manages the trust, and makes decisions regarding the farm. Family trusts offer tax advantages and asset protection, as the assets are held separately from the individuals, but they also come with specific legal and tax complexities. When considering family trusts in property settlement, it's important to go into it in a little bit more detail. The following aspects may be taken into account. This includes who has control of the trust and who are the beneficiaries. If one or both spouses are beneficiaries or controllers of the family trust, the assets are held in the trust may be considered as part of the overall property pool available for division. Another is contributions. The court may consider the financial and non-financial contributions of each spouse to the family trust during the relationship. These contributions can include initial funding, ongoing financial obligations, and any significant efforts made to increase the value of the land held within the trust. Discretionary trusts. In most cases where the trustee has discretion over the distribution of trust assets and income, the court may exercise its power under Section 75(2) of the Family Law Act, where we look at the future needs consideration of the spouses to adjust property interest to achieve a just and equitable outcome, including accessing trust assets and income. It's also important to note sham trusts, as in some cases a family law trust may be considered a sham if it was set up solely to hide assets or frustrate the property settlement process. If the court finds that a trust is a sham, it may disregard it when dividing assets between the spouses. Returning back to the types of ownership of a farming venture. Another is company. A family farm can be structured as a company where it becomes a separate legal entity from its owners, who are the shareholders. The shareholders, who are typically family members, own shares in the company and elect directors to manage the farm's affairs. A company structure provides limited liability protection to shareholders, meaning that personal assets are generally protected from the company's debts. However, there are strict legal and reporting requirements for running a company, but it can also be tax effective. Another is a joint venture. A joint venture is a cooperative arrangement where 2 or more parties come together to undertake a specific farming project or venture. Each party contributes resources, capital, or expertise to the venture and shares the risks and rewards. Joint ventures are typically governed by a formal agreement that outlines the terms of the collaboration. Family Farming Partnership Trusts. The Family Farming Partnership Trust is a specific structure designed for Australian family farms, particularly those transitioning from one generation to the next. It combines elements of partnerships and trusts to provide asset protection and tax advantages, while allowing for a smooth transfer of ownership within the family. Question number 3 of issues that can arise in farming matters in family law. Are there any actual or potential third-party interests to be considered, such as siblings, parents, or adult children, when determining the division of the assets between the spouses? It's important to identify all relevant third parties with legal and equitable interests in the farm. This may include siblings, parents, and children who may have ownership shares, joint tenancy, or beneficial interests in the property, including as beneficiaries of the family trust, which may hold the family farm and its assets. Consider the contributions made by each family member to the farm. This includes financial contributions, labour, and any other support provided over the years. Understanding each person's entitlement will help ensure an equitable division of assets. It's important to encourage open communication and mediation among family members to address their interests and concerns. Mediation can be a valuable process for resolving conflicts and finding a mutually acceptable solution. It's also important to obtain a professional valuation of the family farm to determine its fair market value and the division of each party's and third parties' equitable and legal interest in the property. The valuation will serve as a basis for negotiating the property settlement. Consider different ownership structures that can accommodate the interests of third parties when considering a settlement. This can involve forming a partnership, trust, or a company to hold the farm's assets and distribute benefits among all the different family members with an interest. And also explore the possibility of creating binding financial agreements, known as a prenuptial or a postnuptial agreement, to formalise property division and to protect the interest of third parties in the case of relationship breakdown. Another relevant consideration is who holds or owns water rights. Water rights are a crucial aspect of property settlements involving family farms, particularly in regions where water resources are limited or where water plays a significant role in agricultural operations. When considering a property settlement involving a farm, the following issues around water rights need to be taken into account. Water entitlements refer to the legal rights granted to a landholder or user to access and use water from a specific source, such as a river, lake, or groundwater. These entitlements are typically regulated and administered by government authorities, and they can have a significant impact on the farm's productivity and value. In addition to water entitlements, water allocations determine the actual amount of water that can be used from a specific source in a given period, usually annually. Water allocations may vary based on factors such as weather conditions, water availability, and government policy. Water entitlements and allocations can be bought, sold, or leased in Australia, allowing farmers to trade their water rights with others. Water trading is a significant factor to consider during property settlements, as it affects the water availability for the farm, future agricultural operations, and thereby its value. In some cases, water rights may be separated from the land title, meaning that water entitlements and allocations can be owned by different parties than the land itself. This can add complexity to property settlements, especially if water rights have been bought or sold independently. Compliance with water usage regulations is essential, as failure to adhere to them limits and reporting requirements can lead to penalties and restriction on water access. During a property settlement, it is crucial to ensure that both parties understand and agree to comply with water regulations. Consider the availability and reliability of water in the region where the family farm is located. Changes in climate, water availability, and government water policies can affect water security in the long term. Issue number 5. Who can expect to retain the farm? This decision depends on several factors. There is no fixed rule or automatic entitlement for either spouse to retain the farm. The primary consideration is to achieve that just and equity we mentioned earlier when considering the division of assets by implementing that four-step process. In that respect, the court will take into account various factors, which includes the financial and non-financial contributions of each spouse to the farm and to the marriage and de facto relationship as a whole. That includes contributions during the marriage, before it commenced, and post-separation. Then we look at that future needs of both parties, such as the age, health, income earning capacity, and the breakdown of the care responsibility for children and others. We also look at the financial resources of each party, including their ability to maintain the family farm and to meet their future financial requirements. We look at the total value of the assets and liabilities and how they can be divided to achieve a just and equitable outcome. If there are children involved, the court will consider their best interests in making property settlement decisions. The availability of other assets and liabilities may also influence the division of the family farm by considering how they can compensate one party if the other retains the farm. Further, if one spouse has significant farming skills and expertise, the court may consider their ability to continue operating the family farm successfully. Issue number 6, contributions by the non-farming spouse to the farming endeavours. As I've touched on before, we also look at financial contributions. They refer to the monetary contributions by the spouse to the acquisition, the maintenance and the improvement of the farm, which includes if one spouse used their own funds to purchase the farm and or pay down the associated home loan. Their financial contribution is considered quite significant. It's also important to consider if one spouse invested money to support farm operations, such as purchasing equipment, seed, livestock and fertiliser. We also look at the financial contribution made to building or improving farm infrastructure, such as buildings, irrigation systems and fencing. When we look at non-financial contributions, that refers to efforts, work and skills contributed by a spouse to the farm, which may not involve direct monetary contribution. These are essential in recognising the value of the spouse's labour and dedication to the farm, and examples include physical work into the farming activity, such as planting, harvesting and caring for livestock, the skills and expertise in managing the farm, making critical decisions, overseeing agricultural operations. It also looks at effective farm management, which contributes to the farm's success and productivity. Contributions made to the development and expansion of the family farm, such as exploring new markets, introducing innovative farming techniques, or establishing new revenue streams. Non-financial contributions also extend to the overall support provided to the family and to the farm, which includes emotional support, caregiving responsibilities, and maintaining family harmony. Another style of contribution we look at is the homemaker and parenting role. That refers to contributions by a spouse in maintaining the home and raising children and supporting the farming activities, particularly when the other spouse is heavily involved in running the farm and unable to contribute to a significant extent to that role. Such contributions include efforts in cooking, cleaning, laundry, and other domestic tasks that support the smooth functioning of the family home and farm. If there are children involved, the time and effort spent on childcare and parenting responsibilities. Relevant to this consideration, as an example, is whether the children were homeschooled, placing a heavier burden on the non-farming spouse, compared to whether the children were sent away to boarding school. Homemaker contributions also encompass the emotional support and sacrifices made to enable the other spouse's full involvement in farm-related activities and business commitments. The next consideration is the future earning capacity of each spouse following the breakdown of the relationship and no longer an ability to have a reliance on the financial support and homemaker and parenting role of the other. So it's important for the court to consider the future earning capacity of each spouse and the earning capacity of the farmer which in many cases may be his need to retain the farm. In some cases, however, it may not be feasible for the farming spouse to retain the family farm, and it may need to be sold to ensure a just and equitable division of the overall asset pool between the parties. In that scenario, the court will consider a variety of issues. Some include, are there any potential capital gains tax consequences arising from the sale of the farm, and how does that contribute to the overall asset pool available for division? What will the farming spouse's future earning capacity be in other areas without the ability to farm the land, such as potential employment opportunities or other business ventures he can pursue? We also look at the wife or the non-farming spouse's future income earning capacity as well. What are her skills, qualifications, and job prospects? And we look at the proceeds of the sale of the farm and how will they play a role in meeting the needs of the husband and the wife going into the future. To finish off today, I'll touch on a few relevant cases that have been considered by the court in the area. One of the leading cases is the matter of Jabor and Jabor from 2019, where the full court of the Family Court of Australia dealt with property settlement orders made by the trial judge. The trial judge had divided the net non-superannuation assets of the parties as to 66% to the husband and 34% to the wife. The wife appealed, and the full court reassessed the division of the trial judge to reduce the husband's entitlement down to 53% and increase the wife's to an overall 34%. That was an increase of 13% in the wife's favour. A brief background on the facts to get a better understanding of why the full court of the Family Court made that decision. The parties met in 1998 and married in 1991. They had 3 children who were each adults by the time of the hearing. The parties separated in 2015. At the time of cohabitation, the husband had the former matrimonial home and a half interest in 3 blocks of land. The value at the time was not known, but estimated to be approximately $200,000. He had held his interest in the land 13 years prior to the commencement of the relationship. In 1998, 10 years into the marriage, the husband and the co-owner divided blocks 1 and 2 between them. 3 years later, in 2001, the husband sold block 2, which he had retained, and applied half of those proceeds to buy 1 full share of the remaining block number 3, and he applied the other half of the sale proceeds for family purposes. His interest, therefore, in the remaining block of land was in excess of $10 million at the time of trial, and that was largely due to rezoning which occurred in 2010. The total pool available at the time of trial was about $9 million, not including superannuation, as the parties had already received $1 million each by way of an interim property settlement. At trial in the first instance, the judge determined that apart from the blocks of land brought into the relationship by the husband, the parties' contributions, varying in nature, had been equal throughout the relationship. The trial judge awarded the husband 66% of the net non-superannuation property and the wife 34%, as I said, to recognise the husband's contributions at the commencement of the marriage. It was the wife who appealed. On appeal, the full court held that the trial judge was in error in seeking a nexus between the contributions by the parties to the property and the present value. It considered the trial judge had overlooked a variety of factors, which included the parties' decision during the marriage to use half of the proceeds of one of the blocks to gain sole ownership of the other block. It also had overlooked the parties' decision not to sell the remaining block at an earlier stage, where it would have been worth far less, and also the parties' decision to live a modest lifestyle for 5 years in order to retain that block. The court considered that as the sudden increase in the value of the asset was unrelated to the efforts of the parties, that by rezoning of the land, the contribution was contributed by both of the parties and not just the husband. The full court rejected an argument that an increase in value in assets that were initially contributed by one party should be regarded as that party's contribution as at the time of trial and its value at that time. The full court referenced cases where it was found that the rapidly accelerated value of a property due to rezoning was a mere windfall to which neither party had a greater or lesser claim. The full court therefore reassessed contributions as to 53% to the husband and 47% to the wife, stating that the property was just one of the myriad of contributions made by both parties throughout the long marriage. It stated that the weight attached to an initial contribution must be assessed against the rubrics of all the contributions made by both parties throughout the entire course of the relationship. Another case on point is that of McIntosh and Greer of 2012, which provides an example of how the court considers the four-step process in family law matters, including a significant initial contribution by one of the spouses of a family farm. In that case, the husband, who was the farmer, was 60 years old when he met the wife, who was then 46. The parties had cohabitated for a year and were then married for 7 years. It was the third marriage for each of them. There were no children of the marriage, however, 3 children from the husband's first marriage. The net asset, which included superannuation, largely comprised of the farm inherited by the husband and other assets contributed by him, totaling $12.3 million. And property contributed by the wife to a value of $1.4 million. Justice Dorr held that the financial and non-financial contributions made by the spouse, the wife, since the commencement of cohabitation of the parties in late 2000 make it more appropriate to consider the overall situation, rather than to consider the issues on an asset-by-asset basis. When considering the initial financial contribution of each of the parties to the assets, which have been acquired and maintained during the relationship and since the relationship, together with the financial contributions of each of the parties generally, the significant factors are the assets and liabilities of each of the parties at the commencement of cohabitation and the financial and non-financial contributions of each of the parties has made during the relationship. Of the assets owned by the parties at the time of cohabitation, the interest the husband held in K property is the most significant. The court takes into account the subsequent acquisition of further assets when giving appropriate weight to the contributions of each spouse. At the commencement, the husband had significant and substantial interest in K property, being about 2/3, K proprietors, and the shareholdings through the Greer Investment Company. The significant initial contribution is now represented by a large portion of the net assets of the parties. Taking that into account, and the subsequent financial and non-financial contributions of them both, it is appropriate and just and equitable to treat the contributions of the husband as to 75% and those of the wife as to 25%. The third and final case we'll look at is that of Casper, 2009, which is a case of a married couple for 16 years with 2 teenage children. Justice Fowler assessed the husband's contributions to the net assets of $6 million, being mostly the value of a farm brought into the marriage by him at 70% of the asset pool. The wife's share, which increased by 2.5% on account of the future needs factors, gave her a settlement of $1.7 million, of which $1.4 million was payable within 30 days to enable her to complete the purchase of another property. The balance was payable to her over 12 months with interest to enable the husband to raise the settlement funds whilst retaining the farm. That concludes today's webinar. I would like to thank you all for attending today and learning a little bit about family law for farming, rural and regional clients. If you would like to find out more information on this topic or have more specific topics relating to family law that you need some answers, just email us at law@mlynch.com.au. I also encourage you to complete the feedback survey, which you will be sent at the conclusion of the seminar. Please also take an opportunity to have a look at past webinars that we have released at www.mlfl.com.au. lynch.com.au.